And I
All
think we
right.
are live. We are. Good
Here we are.
afternoon. Good evening, JR. How are you?
Good. How are you, man?
I'm
Because we
good.
never talk. We never catch up with each other, right?
No, so let's pretend. We'll pretend. So it's not legal advice, and JR, and some people like to call him Tiny or Mini, but not me. I don't like to call him that.
Richard, some people also like to call us trauma buddies.
Oh,
Trauma,
I heard that.
not
I saw
trauma,
that. I
trauma.
was I was very, very flattered by that.
Yeah, I was too. He's just upset because I called him Limp Biscuit in a tweet one time.
That,
So
that happens if the shoe fits, as it goes.
I was a little disconcerted by the one part. Now, look, anybody can make fun of me. I don't care. And you know what? You can poke fun at Richard and I. It is what it is. I'm all about it. So Ramen, you have at it. I'm all about having a little fun. But I am a little concerned with the one thing you indicated, that we were somehow the cause of this. Let it be known that I have worked for FINRA. Neither has Richard. I've never worked for the SEC. Neither has Richard. I don't even know anyone in FINRA. I didn't even know about a U3 halt until a month before it happened, and that was by some random Reddit poster. So this notion that Richard and I somehow caused this is ludicrous. So, Ramen, please get your facts straight. But by all means, poke fun at us. I really don't care. That's all I have to say about that. And I've been waiting to say that.
Yeah, I found the accusation kind of funny because it was out of sequence because it said the U3 halt and then they trapped. I think it was like that.
Yes.
Then they trapped us. How does that
Yes.
make any sense? I think the U3 halt was the problem, not anything we did.
I will say this. The one thing that Ramen was right about in that tweet is you and I have become fast buddies. So that puts a smile on my face, Richard. You're a good guy, and we have a lot of laughs. So
Yeah, and I don't think I know I get I have to thank the community. You too. We get a lot of positive feedback. Everybody, I think everybody knows that we have the interest of the community at heart, and so
sure we do.
So be it. Obviously, when I saw it, by the way, just to kind of because I didn't even know we were going to talk about this, but when I saw it, I thought, that's false. So that would be slander. Okay. So could I go after him? Yeah. Am I going to go after him? No. But, somebody probably making those kind of accusations probably should be aware that they might be actionable and they should be concerned. But anyway,
yeah.
I hope he meant it in fun, and I hope he will think about it, and we'll move on from there. I kind of wanted to say hello to somebody out there, my grandson and my sons and my daughter-in-law, my wife, my 2 dogs. Hello to you all out there. And by the way, my therapist says I have a preoccupation with revenge. Well, we shall see about that.
I was waiting for the joke when you said you wanted to say hello to all these people. So
no, that was truthful.
That was real. That was real.
But the one I just snuck in behind that, I hope you could tell, was the real one. We talked a little bit off air. There's a lot of, it wasn't because we have like a list of topics that we're going to discuss, but like today, MMTLP is kind of like fresh in our mind. It seems to be a lot of heat in the air. And kind of my view would be, I wish that everybody could get along, but that's not probably realistic in life. And people under stress after 7 months, I understand how people can be frustrated and maybe not act the way that they normally would act. Perfectly understandable. And I can't get involved in that and deal with that. So the only thing that I can do, and same for you, is continue fighting for the MMTLP cause. So we're just going forward, and kind of part of what we're going to talk about tonight is we're going to talk about FOIA, but there's all kinds of things that we're still pursuing. And in our minds, we're just going forward. So whatever the noise is, it's unfortunate. And I feel bad for everybody involved. It has hurt feelings. I really do. But from our perspective, we can't do anything about that. All we can do is push forward. I don't know what your view is on that.
Well, I mean, you and I have both always, since day one, have tried to stay above the fray. And I'm going to go back to the conversation where you and I actually, the first time you and I talked personally, well, the second time was after a comment was made about the lawyers come in here, meaning me and you, and we stress everybody out by, kind of saying this and saying that, and thinking the way we think about things. And ever since then, I've always been cautious about kind of how I explain things, how I say it, my tone, my demeanor, because, on some level, our words matter. Sometimes I don't like that, but they do. I like to be a jokester and clown around, and I try more to put a smile on people's faces than I do to try and educate people. But, you and I on the space calls in the community, our words are taken a little bit more. So I've always taken the approach that I'm not getting involved in the drama. I'm not picking sides. I try to get along with everybody. I try to help everybody. I don't always necessarily agree with some of the actions we've taken, but I support them. I don't speak out against them, and you don't either. I try to help behind the scenes. I've never considered myself a front man type of person. I can tell you I had 2 separate conversations with individuals this week that had conversations with congressional representatives, or in one instance, a congressperson themselves. I spent about 45 minutes on the phone on Thursday prepping someone, reading over what they were saying, kind of giving them the better, kind of maybe a different approach, something else to think about, something else to drop. That tends to be my strength, and it's always been my strength. And so that's what I focus on. As far as all this other noise and drama, no matter who's involved, I tend to stay away from it. I tend to try and talk to everybody, give reason to everybody, and hopefully put a smile on people's faces.
And, one thing that we've spoken in regard to that, and you correct me if I'm wrong, but we kind of know, and it's along the same lines you just said, we're aware that it's a very sensitive subject. And so whenever we speak, we couch our words very, very narrowly with that in mind. And we've also been aware of the fact that others with the best of intentions may not be kind of in that same discipline. They may not be married to that same discipline, and that may have riled things up unintentionally. But anyway, from this point in time, all we could do is kind of work forward, and that's what we're going to do. So for as far as we're concerned, and unfortunately, this is one of the things we had private discussions about, and I had discussions, I think, with Edward about it too. From the start, I knew time frame was unknown, and neither of us rained on that parade. So to the extent that people were suggesting other time frames, we don't really know. So we're not going to shut it. There's no benefit to shutting anybody down, but we suspected that it might take longer than it was hopeful. And we're kind of there, but we understand the impact it is on the community.
Well, here's something else that's important, because I was talking to an individual earlier this week, and they asked, how come I'm not on Spaces? They didn't ask why you're not. They asked why I wasn't. And I said, well, first and foremost, most of the Spaces that I attend are during the day, and I needed to get caught up on regular work because I had been falling behind because I had been on so much Spaces so much. But I also said that, I find, and I know you feel the same way because we've talked about this, but I find this YouTube channel is more intimate. We have a little bit more freedom to talk and expound on things. We get a bunch of comments coming in. We try to answer the questions, but I feel like we're able to kind of educate and talk a little bit more thoroughly about the topics without being kind of bombarded by a multitude of questions, sometimes questions out of left field, sometimes questions that we've answered 10, 15 times already. I find this to be, I think, first, it's more beneficial for me. I feel more comfortable here. But I feel like we're doing a better job at educating the community and keeping the community focused on what we all think is important, not just what you and I think are important.
Yeah, I was going to say, it's like part of the problem I have is, attention span of a gnat. So, 5 seconds pass and it's gone. And so on Spaces, sometimes you want to talk about 5 points, and point 2, somebody takes you in a direction, and you don't even remember where you're going from then. And it's probably not beneficial to the group in large part. So I agree with you. I find this forum easier to kind of get out better information, and so hopefully that shows through. And let's talk substantively about MMTLP. You know, I don't know if anything specifically has gone on in the recent time. I think, you know, nothing. Well, maybe you could talk to that actually.
I mean, I'm not aware of anything new. I mean, the biggest thing that I saw this week was from C-Plant with the well permits that were approved. Now that just tells me the permits were approved. I don't know how quickly they have turnaround time or anything like that. I mean, the one thing that I've always and I've said this publicly is, you know, look, we have the assets to look forward to. You know, yes, there's been some dilution to get the working interest up to 100%, but we still have the assets. And I'm going to quote Gray on this. And Gray says it all the time, and Gray says it with a lot of grace. You know, McCabe wants to be paid. Our chairperson wants to be paid, and when our chairperson gets paid, we are going to get paid. So what's good for Greg McCabe is good for us. What's good for John Berta is good for us. So that's not to take away, you know, what Drew and Junk and all the kind of space leaders have been pushing, which is reconciliation equals resolution, because I still firmly believe in that. But as time has gone on, I've gotten more comfortable with where the assets are. I'm talking intimately with Bill Pecos and seeing C-Plant's posts. I feel more confident that the assets are there, that the company is going to either develop them for exploration purposes or maybe even move into production. I don't know. I don't know enough about the oil industry and gas industry to know how easy it is to do that, how quickly the turnaround. I just don't know anything other than it sounds really good to me, you know, exploration and production. So that's kind of where I'm at with it in terms of the entire big picture. That's not to say that I'm not going to continue to push for people to call Congress, people to talk to Congress, and I'm going to continue to do what I've been doing. But really, C-Plant's post was the only news I saw this week.
The one thing I became aware of, and I may have referenced it somewhere, was Will Stewart, who said he was going to transfer his shares to AST. He sent me his account statements showing that the shares had been sent to AST. So he did move his shares. You know, it's approximately 20 million. And again, not financial advice, not legal advice. It's not even medical advice, or it's not even pharmaceutical advice. But, you know, whatever he did is great. But whatever you decide, you should decide. And I say this, I try to say this every episode. If you have some major decision you're going to be making that's going to affect your life, find an expert you trust and get their opinion before you make that kind of decision.
Right. Well, it's funny you say that because I had an individual ask me some pretty poignant legal questions earlier this week. And, you know, it's kind of funny. And look, I respect this guy and I appreciate his questions and I appreciate what he's doing. But it's almost like the community is trying to twist the question, ask the question the same way to try and get that, you know, another answer. And I came back and said, look, the only advice I have for you is you're asking a very poignant legal question. You know, I advise you to seek legal counsel immediately. And then I have this whole spiel I go off on. And
yeah,
you and I talked about this. I don't have liability insurance, so I don't give legal advice.
And yeah, not only that, it's you know, from a practical standpoint, if somebody comes to you for legal advice and you give them legal advice, you're on the hook.
You're on the hook. That's right.
Yeah, even if they pay you diddly, even if it's just kind of like a casual conversation where they seek out advice. That's why we're constantly saying, we're repeating, not legal advice, whatever.
Yes.
Because every case is different. You know, the specific facts matter. So anybody who would give you like, here, follow this advice specifically without knowing all the particulars, that's not somebody's advice you want to follow, to be honest.
Right. Well, you know, the one that I remember is from professional responsibility class. And I distinctly remember my PR teacher or professor telling us, look, if someone asks you what the statute of limitations is for X, Y, and Z, and you give them that statute of limitations time period, you've now just given legal advice. It's that simple. And so that's a pretty thin line if you think about it, the statute of limitations. I mean, you can Google it. You know what I mean? But for an attorney to answer a question on statute of limitations and potentially be on the hook, that's some scary stuff. It's scary stuff for someone that doesn't have liability insurance.
Well, scary stuff, period.
Yes. So I tend to, I tend to talk very generally, even when I was talking about your case as it was working its way through the system, I tend to really articulate and think about the words that I'm using as I'm answering some of these questions. And if I don't like the question, my response is you need to seek legal counsel.
Yeah,
So,
and pretty much the same as I get DMs constantly, and I'm happy. And by the way, I try to respond to everybody, so I try to do that. But people asking me questions, and I have to nicely respond in a non-responsive way, and and hopefully I do it in a way that satisfies people. But
right,
we'd like to answer everybody's question. It's just not feasible.
right.
But finishing up on MMTLP. So the other concern I continue to hear is, what, and this is the commentary in the background. What's NextBridge doing? What's MMAT doing? So I'm told things, but I don't know if they will occur. But I'm hoping that something will occur soon. And I'm not just throwing it out. We've spoken, obviously.
Right.
But I think they are actively working on it, and I'm not just making that up. But what that turns into, I don't know. And I don't believe, at least as of this point in time, even if something were to be done, and I think they are going to be actively involved, more certainly than they have been in the past. But the expectation that it's going to resolve something overnight, I don't think is a realistic expectation. And I know people who are struggling, are looking for the beam of light. And we were talking before, so we started off strictly and only focused on MMTLP, but we figured since there's a lot of companies in similar positions, that we might find things in other companies that might help us in the MMTLP situation.
Right.
And we have it seems like we have been able to do that. But in dealing with all the communities involved in those other stocks, they had that same anxiety, unhappiness. It's a common feeling. It's really unfortunate. There's a lot of people that have been disenfranchised, and it really is sad. It's not like we don't get it. I really feel bad for all those people. And there's thousands, tens of thousands.
Well, if you look at it kind of from that 36,000 foot view, people are upset because they see the corruption going on, and I've only recently started to think about our government and our regulators in terms of corruption within the last 6 months being involved in this. I was one that had faith, and you and I've talked about this. I used to say I was the only person in America that still believed O.J. Simpson was not guilty because 12 men and women said so. I had a lot of faith in our government and a lot of faith in our judicial system. Now, I still have faith in our judicial system, but I'm quickly losing faith in our government. And people are becoming disenfranchised because they see the corruption in front of them in the markets every single day. Look at Alpine. Alpine should not be operating. Alpine should have been out of business months ago. FINRA could have taken them out of business months ago. FINRA can still take them out of business right now, today. And yet they wait. They wait. They allow this organization to, and let's be realistic. They went after FINRA because they were cheating the DTC out of money. They didn't go after FINRA, or FINRA didn't go after Alpine to protect retail investors. DTC called them out when they said they had a concentrated short position in GTII. So the pisser of all this is, and the reason why people are disenfranchised is because we now figured out the game. We've now beat them at the game by buying and holding stocks and not trading them every day and allowing them to mix naked shorts or close their counterfeit shorts or bankrupt the company by naked shorting them to death. We figured out their tricks, and they're still allowing it to happen. They've not said the gig is up on you guys. You've lost. The game is over. They still allow it to continue every single day. And that's why people are disenfranchised.
Yeah. And again, the quick summary on that is April 2022, cease and desist. Don't do any bad stuff anymore. April 2023, a year later, after they found 35,000 violations. So I can only imagine what the actual number is. If they found 35,000 violations, they start action. The Court of Appeal, and again, correct me if I say anything incorrectly. The Court of Appeal, after there was a bunch of other proceedings, but eventually gets to the Court of Appeal. The Court of Appeal basically stays FINRA from conducting the exit interview for Alpine, and has some strong language about FINRA and their future position that suggests that perhaps FINRA is going to lose to Alpine in this particular proceeding. But that doesn't limit FINRA. FINRA can go into federal court and take care of business. They know that the public's being harmed because they found that, but they're still not doing. If anything should be brought to the attention of Congress, it's that. How does FINRA justify not acting when they found the misconduct?
Right. And it makes you wonder at what point they got to 34,999 violations of a permanent cease and desist order and had finally had enough. I mean, that just say that with any other individual. You'd have violated a cease and desist order 35,000 times. You would have been found in contempt of court many months ago, and you'd have been hauled off to prison or you'd have paid a hefty fine. But not this organization. Why?
Yeah. So if they're not, the question would be if they're not capable of policing. So this is not even policing like some anonymous. Like, this is not the MMTLP where we call them up and say, you got to check this out. This is something they're doing themselves. They're conducting the investigation. They're doing the prosecution, which is a problem, by the way. That's a problem, apparently a constitutional problem. But they're doing it. So they're on top of it. It's right in front of them, and they still blow it. So does that mean they're just not capable? Because if they're not, we have, again, and we talked a lot about this. If they're not capable of supervising the industry, then they can't be in that position. That's just that's not complicated. If they can, but they're not for some other reason, that ain't right either. Right. So it's one or the other. Neither of them are good answers.
Right. Well, the other thing too is they're not chasing Jack the Ripper here. They're not chasing some unknown individual who they're trying to figure out the identity based on all the circumstantial evidence they compiled. I mean, these guys have access to some of the most powerful, some of the most intelligent computer systems. Do you know in healthcare, the systems that they use to keep track of electronic records, to keep track of patients, every keystroke is logged. So if I'm a nurse in X, Y, and Z hospital, and I see, Richard's file, Richard comes in, he gets admitted, he's on my floor, but he's not my patient. But I want to check out and see why Richard's in the hospital. And I log into your record and review it. I'm getting a call from HR and my supervisor saying, you violated HIPAA. You were in that record. You didn't need to be. Why were you in there? And what were you doing? Now that's simple, basic HIPAA controls. You mean to tell me FINRA can't sit at their computer screen, pull up Alpine and review all their trades and find out what the hell they're doing? And if they can't, they're complicit because they don't have a system like that, and they damn well should. If they're not doing it, then they're either lazy or they're part of the problem.
Yeah, I mean, if Mr. Cook is being paid, I think it's $3.5 million a year. That's what's disclosed. The disclosed amount.
That's disclosed. Yeah.
Yeah. If he's getting paid that, he needs to be a really good CEO.
Yeah.
And the only way we could see that he's a really good CEO is if his plans are effectuated throughout the system of the company. And if this is the best that they could accomplish, then we're not getting our money's worth. And
no, we're not.
No, we're not. And that's what, that pisses everybody off. And again, I was going to say, as to Alpine, just to clarify. So even if, and part of this is we want FINRA to act in federal court now, because we don't want them to wait to let the appeal to play out and see what happens, because that's just going to kill time. And they could accomplish the task now. And I don't want them not to, this was the other part that concerns me. I don't want FINRA, the SEC, not to file in federal court because they want to preserve their position that they have the authority to conduct all these proceedings through the administrative body. They're trying to, they're already setting up their arguments for the Supreme Court. That really is not fair to the investors, in this case.
Well, I think given the amount of violations, they could go into federal court and still preserve that argument. Look, Your Honor, we didn't have time to waste with this. They've been violating their permanent cease and desist order 35,000 times. But as a sitting judge, I would say, well, what the hell took you so long? You allowed them to violate it 35,000 times and now you're coming into court? I mean, it's almost to the point where it would be extremely comical if it weren't so sad. I mean, Robert Cook, for example, this guy's a blowhard. That's it. He's nothing more. He's a figurehead. He leads an organization that, quite frankly, does nothing, is supposed to be protecting and transparent, yet they've hidden behind the cloak of, well, we can't share that information with you. I mean, I'm still mind boggled. What's the problem with a corporation saying, I want to know how many shares are in the market right now of the security that I've issued? It's a simple question. Provide a simple answer. And yet no corporation can do that. So this notion that FINRA is for transparency, it's laughable. Cook can go in front of Congress and use all those big words and put on a damn good show. But at the end of the day, it's all meaningless. It's all empty words.
I think to the crowd that aren't in the capital side, it's obvious.
Yeah.
And I think the evidence is empirical. So whereas in the past, I don't know, 10 years ago, maybe people complained about the same thing, but they didn't have the ability to demonstrate it. Just the information was not as easily accessible. Now, I think, amongst a lot of people, we just kind of accept it as fact and we're working to, get a remedy for it. It's not a question whether it exists or not. It's a question of fact. One thing we talked about, and I was going to address it with you because it kind of goes along with the same point where people, again, because people get all kinds of information through YouTube. And they may be Twitter, they may be misdirected. And it's very easy for somebody to get misdirected. It's not their fault for being misdirected. Because somebody who's intending to misdirect is usually good at doing that, or else they wouldn't be doing it. A con man is usually pretty good. And that's why they get people to follow suit. So AMC, I don't know if you invested in AMC, I did not. But, again, it's an issue of shorting, and there was a recent ruling in a case, and I found it really interesting. So on Friday, there was I don't think it was even official. I don't remember how it was presented, if it was a press release or discussion, but the news came out that the judge had denied the request basically to dilute the preferred into common and issue some more shares and I do a reverse split. So the judge said that. So everything that was at least what I saw, maybe you saw it differently, but what I saw was everything was presented. It was like a end of the case, done, no settlement, we can walk home, and now the stock's going crazy. And I remember after hours, I watched it, after hours, the stock I think was up as much as maybe like 90%, and it might have closed up 60 or 62%.
Yeah.
So then I discovered I was interested, and we were going to talk about it today. And then I hear about this paperwork that's filed after the decision. And in the paperwork, it's so this is analyzing what the judge apparently wanted. And it was something that was prepared jointly between the plaintiff's counsel and the defendant's counsel, which means that everybody was on board. But But I think in Delaware, any class action has to be certified by the court, has to be signed off by the court. So they submit this settlement to the court. The court looks at it and has a problem because there's a release of I think the APE shares are preferred shares, and they're not a party to this particular settlement agreement. So you can't take action against somebody who's not a party to the deal. So the judge, I think, communicated that, and the attorneys worked all night, prepared something, filed it in court, and now it'll be considered. And to me, if it's as was presented, and if that was the only hurdle to go over, then I would think the judge would sign off. And then the preferred would keep their, I think in essence, the preferred keep their claims, and if they want to pursue them later on, they can.
Right.
But I guess the only other issue is there's no notice. So this is being done. This new amended settlement is done without notice to any of the shareholders.
Right.
And there will be a claim, I think, that they should get notice, and maybe some of the, because there were a lot of objections filed. I think they said there was 2,900 objections filed. So I would suggest, I'm not in it, but if you filed an objection before, why not contest notice now? You're going to do it. Why not?
Right.
But the judge seemed to be inclined, to maybe accept it as a deal, and it was presented otherwise, and it was presented as definitive. And I know because we talked about it. So the stock goes up like 90%. All these people made a ton of money on Friday, but they're stuck. Yep. And this comes out over the weekend. And again, not financial advice, but I would expect probably the stock won't do particularly good when the market opens on Monday, is my expectation, because whatever the expectation was on Friday is no longer the expectation.
Yeah.
And all these people are going to be pissed. And what specifically I was tying that to is, so I watch a lot of these YouTubers. I watch them with a lot of skepticism. And I still do my own conclusions. Yeah. And if I happen to follow one of their opinions and the thing goes south, that's on me. I'm happy to accept that. But this afternoon, so it would have been like 5:30 your time today, there's a guy, I'm not going to say his name, but his name rhymes with Hawk Joe. That's the name of the YouTuber. Hawk Joe. He has like about 700,000 subscribers. And he is pumping AMC at 5:30 today.
Yeah, I will tell you, I don't know what, I mean, I personally think it's anyone's guess on what the share price is going to do. But I do think, like you, there was a lot of confusion over the judge's ruling on Friday. And I'm not surprised that the decision came out, 4:30, maybe 4-ish. And by midday Saturday, the attorneys for both parties had submitted a revised settlement. And they outlined why they don't believe notice is required. I tend to think that, given how articulate this judge has been, the judge is acutely aware of the retail following in this case, to the point she assigned a special master to review all the letters, all 2,900 letters that they received. They put them in categories, and the special master dealt with the ones that they thought were relevant to the case at hand. And the judge made multiple comments about that in her opinion. So even if they met the notice standard, I would be surprised if this judge doesn't say, no, you're gonna send notice out. Because, to your point, you've already filed an objection. Why not file an objection over notice?
Yeah.
And I'm certain it'll be reviewed, given how articulate this particular judge has been. I told you this right before, and I saw it 10 minutes before you and I connected. Adam Aaron put a lengthy letter out about what's going on. Now, I didn't read it, but I was reading the comments that after he had posted the letter, and the AMC folks either love Adam Aaron or they hate Adam Aaron. I don't know, which is the right answer, but the community is definitely, divided on that issue of Adam Aaron, whether or not he's helping or hurting. I have my own personal feelings on Adam Aaron when I was in AMC. I'll keep those to myself for now, but and I'm not in AMC. I just want to be very clear. What I know about the court case is what you and I have talked about, what I read on Friday, and then late yesterday I read the attorney's response, and then there was another letter that was sent out that I read, and then I didn't get the opportunity to read Adam Aaron's letter, but it was pretty lengthy. It was like a 2.5-page, 3-pager. So I don't know what he said.
Yeah. So, from our perspective, I guess we should be clear on this. We're not like making any, other than like MMTLP and those kind of stocks, we're not making any suggestions as to an outcome. We're trying to kind of like give you the status, really,
Right.
in English is really what we're trying to do.
Right.
And we're not capable of a lot, but we might be capable of that.
We're not necessarily good lawyers, Richard. Just
not necessarily, but we could be though. That doesn't like rule that out.
I'm sure I could bore you to death with ERISA and HIPAA and healthcare reform if you'd like, but that's
you've already done that.
But that's not why anybody watches this YouTube channel, right?
I hope not. I hope not. But you know, I was going to get into that site, but the YouTubers. I think there's a lot of YouTube. I have a problem. This is my problem. YouTubers who are getting paid and making stock recommendations. And I don't even think it's even necessarily about the particular stock they're getting paid on, but it's hard to say that something's bad if you're getting paid, right? And I just think there's a conflict that impacts credibility so much that it makes me uncomfortable. Listen, we have enough, as we've seen, there's enough reasons to be uncomfortable just without that kind of stuff. If you add that extra conflict, who's not going to be motivated? Some guy has a YouTube channel, somebody comes to him, gives him 25 grand, promote the heck out of this.
Yeah. I have serious reservations about that, to be honest with you. I don't know if I feel very warm and fuzzy about stock promoters being paid on YouTube. I don't know. Something doesn't sit right with me. And look, I'm not pointing out anyone or anything like that. It's just the concept of company A, B, and C paying me, a lump sum to talk about X, Y, and Z ticker symbol. What if I see something negative? What am I supposed to do? I'm
waiting for the Ninth Circuit to approach us and give us like $100,000 to give them like props. The Ninth Circuit is fantastic. They are just great.
I'm waiting for the Third Circuit to pay me to
go for the Third Circuit. But it really makes me uncomfortable. And there are people that disclose it, so that's at least disclosing it. But if you're getting paid enough and they tell you why don't you keep it quiet, and people bitch at you afterwards, but probably nothing will happen to you. But it certainly smells of unethical. And most of all, just you're not given the best. So if you're promoting yourself, you're giving information that's accurate, you're already compromised. So again, the gentleman, I'm not going to say his correct name, but Hawk Joe promoting AMC at 5:30 on Sunday, knowing what we know, I just think that's
I think for me, it's going to be interesting to watch. I will probably wake up at 4 o'clock tomorrow and just to be paying attention to it. Again, I'm not in AMC, Richard. I don't think you're in AMC either. We're looking at this solely from, this is a fascinating story. And I have watched AMC over the last two and a half years because, I was part of the Reddit community for a little while, and then I just moved on. So it's going to be fascinating to watch how this plays out over the next week.
Yeah, and just to complete my thought, if you hear you could use us for examples. If you use YouTubers that just sound ridiculously stupid or say stupid things, and you're trying to rely on that, you really shouldn't. And I'm speaking
or not necessarily intelligent things. Let's say it like that. Not stupid, not necessarily intelligent.
There's just, oftentimes we hear something and a bell goes off and we may rationalize it. Whatever. But usually people are pretty intuitive, and when something's off, they sense it. So just trust yourself, trust your senses. When you hear somebody and it sounds like it's too good to be true or something sounds off, trust yourself. Because I think people get taken in by, and we're just using YouTubers as an example, all kinds of con guys. That just happens to be like the one that we're the mode and medium that we're dealing with right here. So be careful. Be careful. That's kind of like the premise. One thing I was going to go over, and I didn't know if you saw it, it's on our list. Did you hear? Oh no! Before we go on, I know you wanted to talk about note taking. So why don't you take us there?
Yeah, so I had a couple of conversations with folks in the community about, phone calls that they've been having with people, and I talked to this person and they said X, Y, and Z, or I talked to this person and they said A, B, and C. And you and I actually talked about this very early on when people were calling their brokers, and we talked about what are basically called contemporaneous notes and why taking contemporaneous notes are important. And so, when you're having these conversations with individuals, whether it's your broker or whether, and we're going back to MMTLP, sorry. So when the community members are having conversations with their brokers or calling someone, a congressman or something like that, you need to be taking notes either as the conversation is happening or immediately following the conversation. And that's called contemporaneous note taking. And the reason that's important is because that actually can be admissible in court as fact if it's established that the note taking, that they're contemporaneous notes, meaning you took the notes during the conversation or you took them immediately after. And so I found what I thought was a really good definition. Contemporaneous file notes are beneficial to the author as if called upon in future litigation, they may be admitted as evidence to substantiate a claim of an oral conversation. That's very important. That's very important. That no longer becomes a he said, she said. It's a you said it more kind of analysis. And so when we talk about note taking, what are we talking about? Well, you need to document the time the conversation happened, the date the conversation happened, who the conversation was with, as much of the conversation as you can remember. And what I would suggest is you type it up, print it up, and then sign it and date it, or you handwrite it. For me, I'm the typer. My handwriting is atrocious. But that's why that's important, because that can actually be submitted as fact for an oral conversation that took place in a court of law. And as you know, we've gotten a lot of A, B, and C broker said this, X, Y, and Z broker said this, C, D, and F broker said this. Well, if you didn't take the notes and you're sitting on the witness stand at some point in the future and trying to explain that conversation, that's when it becomes a he said, she said. So that's why taking those notes, again, contemporaneous note taking, is so important.
Yeah, and the logic, it makes sense. Memory fades. So
Right.
If I try to remember something that happened 3 months ago, my recounting of details will not be as good as 30 minutes after the event.
Right. Well, I'm going to tie it back to ERISA and healthcare and retirement plans. When I oversaw the benefits department at the airline, we called it the 3 Ds. Do you know what the 3 Ds are, Richard? There's the 3 Ds and the 3 Rs. Do you know what they are?
I do not.
Document, document, document. Relationships, relationships, relationships. Those are the two most important things you can do. Well, again, from a human resources standpoint, whenever you have a conversation with an employee, you document, document, document. And human resources, remember, human is the first part of resources. It's about relationships. So yeah, when you're having these conversations with people and you're building these relationships with the person you're on the other phone, on the other line with, yeah, you want to be documenting and you want to be building that relationship to glean more information in the future.
And along those lines, and it happens in other litigation also. And I think we talked about it early on. That's like 6 months ago. We talked about it. But if you have a legal claim and you're suffering, like anxiety, you can't sleep, and you keep a diary, in effect, the same kind of idea. You keep a diary, you've kind of proven up your damages, to the extent
Right.
you're claiming emotional distress damages from the event, and you keep a record. It's really powerful because, in front of a jury, people believe that stuff.
That's right.
If they believe that's true. It's so, and it's not too late, by the way. So let's say today, you want to start today and you have like a bad dream, you're having nightmares over this or whatever, depression, keep a document. There's no
right.
harm in keeping the document. And, again, this is like 143 years ago, I was a psych major at UCLA. So generally, if you express those kind of emotions, it may make you feel better too, as a side issue. But
Sure.
We're just talking from a legal standpoint. You're kind of setting forth what your damages are. So I think it's a good idea, and I'm glad you brought it up. And even if it's not in the, by the way, even if it doesn't apply to the current situation, as a general rule, it's a good idea to do anyway.
Sure.
So if you're in other disputes or important events, just keep track. Make sure you have a record, a clear record of it.
Right.
Okay, wonderful. Now I'm going to get back to something I found funny. So, in contracts, you have to have like assent to a contract. So so this is like law school.
Mutual assent.
Yeah, offer acceptance, consideration, mutual assent. So, and it's got to be a legal contract.
Yeah.
What is assent? Sometimes, it could be hard. So if you're on a contract, a document, you sign it, and that's easy to figure out if somebody has agreed to it. But perhaps you might have an oral agreement, and sometimes oral agreements can be difficult to prove up. So there's a case in Texas where I think it was a farmer and maybe a supplier, and I don't remember which direction it went, farmer to supplier or supplier to farmer. They have an agreement, apparently an agreement. So farmer says to supplier, give me 50,000 pounds of X. Farmer sends him back, texts him back an emoji with a thumbs up. That's the send. The court found you agreed, you can enforce the contract. So it'll be interesting to see it'd be interesting to see as like, because that's not English, right?
No.
So it'll be interesting to see over time what kind of symbols become acceptable in legal parlance.
It's interesting. Interesting. Yeah. I don't know why, as soon as this popped in, as soon as you said contracts, offer acceptance, and mutual assent, it made me think of the very first case we read in contracts was Lucy versus Zemer, and the phraseology from that, high as a Georgia pine. That's all I remember from that case.
Okay. The problem is what the problem is in law schools, they don't all use the same textbooks. So even though they teach you kind of the same principles, they may give you different cases to kind of illustrate those principles. I remember Paul's graph. You remember Paul's graph? That's like on a river and a bunch of explosions on the river and who was liable. Okay, we got one in common.
That was torts. That wasn't that torts?
Was torts. That was torts. That was torts. I wanted to talk a little bit about, and we've raised it, but it's kind of gotten to a different point, and we find this interesting. And I'm speaking for JR a little bit. We're talking about Sorrento Therapeutics. We've kind of gone over this. It was a bankruptcy, naked shorting, court intervened, issue a temporary restraining order. Then the parties apparently got together. They worked out some deal where the naked shorts could buy their way out by either buying shares in the public market or buying them directly from the court. From the company. And they have a specific period to do this, and they will get released, a full release as to the naked shorting. I don't know what about the other stuff, but specific as to the naked shorting claims. Right. Doesn't apply to the brokers, so the brokers are still on the hook for whatever. But these guys can get out if they cover in the means provided. And there was a mechanism set up also where the value of that particular share could be established. So in effect, because this was in a bankruptcy, there was somebody called like the representative of the company that was basically in charge of setting the value. It was not somebody connected to the naked short holders or the brokers. Right. And there were some other parties that had to be consulted, and probably the court ultimately has to sign off on it. But the way it was suggested, you could get a fair price. So the naked shorts have until the 20th. So this happened on the 21st, which is Friday.
Yeah, it was Friday.
Yeah, so it's the 27th to take advantage of that.
Take advantage of that.
Right. And that would get them off the hook. And I don't think I don't know this for a fact, but their names are confidential at this point in time. So right. I bet you if they cover, that's also going to include a confidentiality provision. So we won't know who they are. Right. Whether a court could order that disclosed, it's possible. In other words, you could have a separate case. You could make a motion. You could say, Judge, could you go let us get that information? A judge might say yes. But it'd be interesting to see how many of those take advantage of it.
Right.
There was also an offering that was made, I think 13 million shares, but we don't know the number of naked short shares, right?
Right. We don't know the number of naked short shares. We know that they did an offering on Friday. They amended their S1 and did an offering of an additional 13 million shares. The offering price was what, $5.69? So we speculated that might be the offer price to the trapped naked shorts. They could get it for $5.69. And that was at that point in time when you and I were talking about that, the share price was $5.83.
Right.
Now, what it is right now, what it was after hours, I don't know, but I'm suspecting it probably dropped below that offer price.
Yeah. So the question is that 13 million shares, is that supposed to cover the entirety, or is that just kind of like, because, to be upfront, I've had discussions with many people discussing MMTLP and how it might play out. And when they were talking about how the shorts might cover, there were basically tranches that went out. So maybe the first, and there wasn't specific discussion, but maybe the first 10 million shares, we'll sell those at $7. The next 10 million shares, $15. Right. So we don't know if that 13 million is supposed to cover the entirety of the short position or just a portion.
Well, think about this. Because I was thinking about this earlier today, knowing we were going to talk about this, but think about this. That whole offer, that whole order that the judge signed off on, my guess is the creditors or the equity committee that drafted that with their attorneys probably knew who, and remember, they were having conversations back and forth on how to move forward. So I suspect the equity committee knew exactly who was going to take that deal and offered the number of shares to, and maybe some additional, to offer the groups that were going to take that deal to get them out of the way. And so then they're going to fight it out with the rest of them. They probably already know who was going to take the deal and who wasn't based on conversations that they had. But the article that we read about this, which the order didn't say, how many 160 brokers received that offer letter?
Yeah. Yeah.
So I speculate they knew who was going to take the deal beforehand.
Yeah,
so it's going to be interesting to see what the next move is after the 27th. If the judge, I'm sure they're going to come back to the court and say, we've settled these claims.
Right.
These people are out. And I'm going to be curious to see what then the next step the equity committee does in terms of this adversarial complaint.
It'd be interesting also because we expect that some of them will bail, because if they don't have like a significantly bad position, why not get a release and get out?
Right. Why have to go into the open market?
Yeah. The flip side is the kind of implications. So this is an action. It's going to go forward if it's not resolved, which means that whoever those undisclosed naked short positions are, they're going to be defendants in an adversarial action.
Adversarial action.
Right. And the guy who settled, who still might have a confidentiality provision, but he's safe. He's got no more liability. So I could take his deposition and I could ask him about shorting of the stock. He could turn in everybody. So I think it's a really dangerous position for the short positions, maybe even more so for the broker dealers in this case, because they're kind of stuck.
I agree.
They got no.
And you're in a case where the judge has already said you're caught. And that's where the complaint's going to be filed. They're going to file an additional adversarial. Well, they're going to move forward with the original adversarial complaint. And you're already in a case where the judge has found evidence that you naked shorted. So I would be dumbfounded if these broker dealers or whoever's on the other side of this trade doesn't take the deal.
And then we also talked about the fact, maybe it's another, and we've addressed it at least at some point. I'm going to bring it up again, that maybe the avenue, because this is in bankruptcy court. And again, just to clarify, there's different kinds of bankruptcy. There's one where you shut the doors and everybody's gone, a Chapter 7, and there's a reorganization. So Sorrento Therapeutics happens to be in a Chapter 11. So they're doing all this within the Chapter 11. It doesn't decrease the shareholder value, but it's a means for accomplishing what they want to accomplish. So we were speculating, maybe there might be some party that might arise that might be, maybe there's going to be a hedge fund who is involved in this. And maybe, just to clarify this point too, so there's bankruptcies where you file, the debtor files, and there's bankruptcies where the creditors make the debtor file. It's an involuntary bankruptcy. So you might have a bad guy, let's make up some name. Let's say Canaccord. Let's just make up some random name. You might have some guy like that who's dirty and should file for bankruptcy protection because there's all kinds of claims pending, but they don't want to do it. So perhaps creditors can then decide to go after them and basically make their books and records available, make them have to disclose information. And again, the difference is, and again, it doesn't make a lot of sense to me, but this is the way it seems to be proceeding, that you can get more information out of the bankruptcy court than you can get out of the federal district court.
Yeah.
So I don't know who. I don't know who would be filing bankruptcy, and if they would. And I even threw out what happens if you have a shareholder who sets up like an LLC, transfers some of their shares to the LLC, and then the LLC files a bankruptcy because he wants to find out what's my ownership interest, what's it worth, and maybe that entity then seeks relief in a bankruptcy court, seeks disclosure like that. We thought it was a way of getting, when we're talking about it, seems like a way of getting around, the issue of the blue sheets and transactional data. It seemed like the bankruptcy court really went to the bottom, right to the heart of the matter, made them disclose the imbalance and the naked short position.
I think it sets a unique precedence for some of these organizations when they enter bankruptcy. I really do, and maybe it's just you and I that think that, but if I'm a corporation and I'm deciding to go into bankruptcy, and let's use Bed Bath & Beyond, for example, they're in bankruptcy. If you go under the premise that Ryan Cohen got involved in Bed Bath & Beyond because he, like retail, knew it was naked shorted to death, they were trying to put that organization out of business. If I'm the bankruptcy attorneys right now in Bed Bath & Beyond, I'm reading over every single decision, every single line by line in Sorrento and trying to see how I can weave it in. Because at the end of the day, that's the premise of some of these or hedge funds that are shorting these companies to death, is to drive them into bankruptcy so that they don't have to pay taxes on the profits, nor do they ever have to close their position. So if I'm a CEO of a company and I'm educated enough to know that, and I take my company into bankruptcy because that's the only way to reorganize it, that's going to be one of my main arguments as a shareholder and as the CEO of the organization. Part of the reason why we're in bankruptcy is because we couldn't go to the market to get liquidity because our shares were naked shorted to death. They went from $20 a share down to 80 cents a share, and we got thrown on OTC.
Yeah, and we know that I think Sorrento's in Texas. The Fifth Circuit is pretty anti-government agency, at least it appears to be. Right. And maybe there's other companies in Texas that could take advantage of those that sequence of events. We'll see. I just think that you and I think there's something there.
I really do.
Yeah,
I think there's something there, and I think you're going to at some point see it utilized a little bit more when these organizations, when these mid-cap, micro-cap, whatever you want to call them, when they finally go into bankruptcy, they can throw their hands up in the air and say, look at Sorrento. This was the exact issue they went through. Here's what happened to us. Haul these guys in here. We're filing an adversarial claim against them. We want the details.
Right. Yeah, I threw that out to. I saw Mark had posted something about BBIG had sought a receiver in Nevada in the state court, and the court turned them down. I don't know specifically why they turned them down. Maybe it was a procedural reason. I think it was without prejudice, which means they could bring it again.
Right.
put out a tweet. He was kind of talking about it, and I responded with this. I said, this kind of is an alternative remedy to the receivership. It would be interesting if somebody kind of took it up. He said he had done a lot of bankruptcy work before, so he didn't dismiss that as an idea. So
Right.
it'll be, again, our position is whatever. We don't really care who it is, whatever works, and everybody's feeling is if it works with one, it kind of ignites the entirety of that marketplace.
Right.
Well,
that's how the court system works. I mean, you know that. That's how the court system works. You take one argument from someplace and apply it to your own set of facts. And I happen to think that the bankruptcy judge in Sorrento figured it out. He knows exactly what happened. He's not letting these guys off the hook. And I again, I can't underscore, at least, and maybe I'm crazy. Maybe I don't know what the hell I'm talking about. I don't know, but I think the importance of that decision has yet to be utilized. And I think we're going to see the impact of Sorrento in the future.
Yeah, no, I agree. I did see, and kind of this takes us to the Gensler point. I saw that SBF got accused of witness tampering. Did you see that? Apparently, It was like sending out, I forgot what the form of communication was, but trying to influence, I think, the jury pool, I guess. And I guess FTX got sued also for like $1 billion. So it was a bad week. And we go back to Mr. GG, Gary Gensler, allegedly kind of tied up with that family, and definitely has a blank on for some kinds of crypto. I did see, by the way, an XRP that there's already an appeal filed, so it's going up.
Yeah.
So,
I will tell you, I'm not as up to date on some of that stuff as other people are in the community. I just think it's laughable that there's such deep connections, and here they are, trying to regulate these organizations when they're in bed with them. It's just, it's yet another example of the SEC and the underlying corruption that's in that organization. It's disgusting.
Yeah. Again, the flip side is just incompetence. If you give them the benefit of the doubt, they're just incompetent. That's not a great side either, one or the other, right?
Right.
I always, projected, when we were talking about the MMTLP situation, I always thought it was a combination of incompetence and corruption, which is kind of like the worst of both worlds.
Yeah, it's definitely a little of both.
Yeah. So we talked about that. One thing I wanted to talk about, we kind of shied away from this, but it's going to be a big issue. So we'll see to what depth we will cover it. We're certainly not offering any opinion as to guilt or innocence or how we feel about the characters involved. Let's start off on that position. But we find interesting, because I think on last week, the document trial against former President Trump was set for May of next year. And I think there's and by the way, there's millions of documents. So it's going to take the lawyers a long time to to sift through the documents. But I found, and I guess there's other cases that might be pending around this date, but we don't know yet how they're going to play out.
Right.
But there's a dance, right? Because we've heard it in the past. You're not supposed to, and I don't even know if there's a specific policy or it's a suggested policy, but you're not supposed to do stuff that's going to, good or bad. I'm not qualifying it that way either. You're not supposed to do stuff that's going to influence the impending election. So the judge kind of picked a date of May, which would be 5 months before the election, something like that. It's pretty interesting. How the parties are thinking, because I heard a little bit of the analysis. So the Trump camp would like all these trials post election, because then they wouldn't have to deal with it in the election. The prosecution wants it tomorrow. That's kind of like where they kind of stand, because the prosecution, they could, and this is true, by the way, of every case. And I heard as I was driving over today, it struck me. If the feds file an action, their likelihood of succeeding on an action they file is something like 99%. They don't file generally stuff they don't believe that's going to win. But in this case, it's interesting to me just how the dance has to be about the timing of the trial, and how it has to be scheduled to not interfere. And by the way, whether that trial date stays, that May trial date, because my expectation is that those trial dates will end up blending into post-election. That's kind of what I figured. But I figured also it would be interesting for us kind of to examine the procedure and testimony as it goes on, and kind of give our feedback, again, for whatever it's worth. I don't think either of us are F. Lee Bailey. At least JR isn't, I don't think. But
no. Remember, we're not necessarily good lawyers.
That's true. I know that's something like, that's like a subject you're not like super thrilled about addressing.
No. Well, I tend to stay on the political sidelines for the benefit of the community. I'm a very passionate person. I can get pissed off about politics just with the best of them. I tend to think that the Trump case is extremely fascinating. I tend to think that most things Trump is involved in legally is fascinating, because he's got the money to pay high-powered lawyers. Now, with that said, I was a hawk watching the O.J. Simpson trial, because kind of the legal procedure and process and the maneuvering and the strategy is always fascinating to me. And I talked about this when you first filed your claim, about everything that happens from the minute that claim is filed is about maneuvering and strategy and process and procedure. And good attorneys that have mastered those skills, the rules of civil procedure, understanding the court rules, understanding the local court rules, tend to be more successful because they use those things to their advantage. Being a lawyer is not all about, standing up and raising your hand and saying objection. It's about creating a record, knowing what record to create, and knowing how to maneuver your way through the system to the advantage of your client. And look, I'm not bragging about high-powered attorneys, but these attorneys, true litigators, they know how to do that. And to me, that's fascinating to watch. So I tend to watch those high-profile cases just because of that fact. And I'm certain that Trump's attorneys are going to do everything they can and utilize every one of those little rules and those little nuggets to their advantage. So that's kind of what I'll be watching for, and I'm happy to discuss it. I just tend to stay away from the politics because it's more for the benefit of the community. And going back to what we talked about earlier, sometimes our words matter, and I don't want to get on politics. As you know, I do a lot of outreach, and I talk to folks, both Republicans and Democrats. I don't care if you've got an RD in front of your name. If you're here to help, I'm going to talk to you, and I'm going to treat you with respect and dignity.
Objection.
Raise your hand.
Oh, objection. Yeah, I was going to say is I'm hoping when we discuss those kind of cases that when we're done, you couldn't tell what side we fall upon.
Exactly.
Yeah.
Exactly.
What we're trying to do here is to explain what's going on, not to give you an opinion as to which side should win. And so we're not going to do that. But I think it would be interesting for people that are maybe not as familiar with the procedure, because it is convoluted and complicated. I think it would be interesting for most people. I agree that it's an interesting scenario. Case of first impression. Nobody's ever seen them. Those are interesting, and how they play out just from a theoretical standpoint.
I don't know why this just popped into my head, but I remember I had been scrolling on Twitter here a few weeks ago, and Trump had made a comment about how this whole trial against him is the greatest witch hunt in American history, and no other president has ever been attacked the way he's been attacked. And one of the comments said they literally shot Kennedy in the head.
Okay.
I was
That
like,
might be
yeah,
slight-
that's
that
right.
could be slightly more.
He doesn't
that
have
could
that,
be,
you
I
know,
guess.
look, Trump's a
Okay.
very verbose person, but he does not have that claim. They
I
shot
agree.
John Kennedy in the head.
I agree. That is a good point. You know, I made us too many topics, but we have to do one more because we've talked about doing it for 2 weeks. So we talked about the FOIA responses, right? Yeah. So why don't you kind of talk about how you see that?
So I've been doing a lot of research into FOIA. I've looked over, as you know, we've talked my FOIA
And
response.
FOIA, just to be clarified, FOIA is what?
Freedom of Information Act. So it's the act in which everyday citizens can request government for information. The spirit of the act is to release unless you can't. So the government is supposed to go under the notion that we should be giving this information unless there's a specific reason not to. And as the community is well aware, we're not getting any information. We haven't gotten any information since Howard's request. We suspect we were never supposed to get Howard's request. I think we're pretty much all in agreement that we shouldn't have gotten Howard's request. And so we get carte blanche responses back. I got my response back for a laundry list of things I requested. Some of them were pretty obvious, which I knew I was going to get denied. Some of them, though, I drafted and created for the sole reason of appeal. Again, making a record for future potential litigation. So I'm working through my appeal right now. I got over Exemption 6, which I don't even know why they use Exemption 6, because Exemption 6 deals specifically with personal medical records and personal information. Now, if you're looking at the blue sheets, yes, Exemption 6 works, but Exemption 6 only works in that one instance. If you're asking for an innocuous number, Exemption 6 does not work, and it shouldn't even be on your FOIA denial. So I've worked through that in relation to my FOIA requests, and I have Exemption 8 that I want to work through because that's an easy one to overcome as well too. But Exemption 7 is the biggest one. Exemption 7, I think it's 7A or 7B, is the one that deals with an open investigation. Now, if you read the DOJ rules, they're not supposed to be using Exemption 7 unless they know that they're going to open investigation, if it's being preserved for a potential investigation, or they're actually in an investigation. According to DOJ guidelines, it can't be, a fake investigation. It's got to be a real investigation. So we know they're in an investigation because Sam Drady admitted to it in his email. It hit his fraud desk and he was reviewing the blue sheets. Okay, so we know the blue sheets are part and parcel with an investigation, so they can't release it. But that doesn't necessarily mean they can't release any information that's on the blue sheets. So you have to, when you're drafting your FOIA requests, you have to laser focus them on specific things. And I did laser focus mine on specific things, knowing full well they were going to throw the kitchen sink at me. I'm not going into great detail about what I requested because I don't want to release any kind of strategy, but I'm working through my FOIA appeal, knowing full well it's going to get denied. And then as you and I talked, we have to figure out how I'm going to move forward. So part of what we talked about at the beginning with contemporaneous note taking is for that specific reason. A lot of people are talking to the FOIA people. They need to be taking notes when they're having those conversations. A lot of people are talking to their brokers. They need to be taking notes when they have those conversations because we know the brokers are in communication with FINRA. We know FINRA is in communication with the SEC. So any little nugget can be helpful information. So that's kind of where I'm at with my specific FOIA, but I've talked to many people about their FOIA responses and kind of how to move forward. I had 2 people ask me if I would actually appeal their FOIA request. And as always, my answer is no, I'm not your attorney. And that would mean I'm representing you and I have no liability insurance. So that's kind of where I'm at with my FOIA. That was kind of what I wanted to get out. There's all kinds of information out there that's available. The March 2022 guidelines on DOJ guidelines on the FOIA exemptions are out there and how the government's supposed to function when they're responding to those things. It's quite interesting, actually. It's a unique situation as well, too, because the burden falls on the government to determine why they can't release the information. So if you ultimately take your FOIA appeal denial to court, the burden falls on the government, which is different because, as we know, the burden typically falls on the plaintiff to prove their case. But in this instance, the burden falls on the government.
Now, how exciting is like a FOIA stuff? That is scintillating stuff. Really,
Well,
that's like a concert. Like your favorite concert. Like that's Beyonce. That was like Beyonce.
well,
That performance.
it's interesting because it's the one area of law where the government outlines it for you. Because the government gives the agencies, DOJ gives the agencies guidelines on how to administer their FOIA program and how to administer FOIA in general. So if you read up on it, it's actually quite fascinating. The standard of review for some of this stuff is pretty easy. And I was surprised as I was reading it. I'm thinking, well, they didn't do that in my response. And so I'm going to force them to answer these questions because number one, I want to know what their answers are. And the other thing I noticed is I love how, and I'm going to nail them on this in my appeal. I'm taking a step back because I tend to do better and think better when I look at the bigger picture and I can articulate my words much more clearly. And one of the things that I'm going to hammer them on is there's a footnote in there saying, because we found, 7A applies, we did not analyze the other provisions of the exemption, so we reserve the right to do so. But yet, not only did they use 7A, they used 6, and they used 7C, and they used 8. So clearly you did, even though you put a footnote in there saying you were going to reserve the right to do it. So I'm gonna make an ass out of them like that because that's the kind of stuff that a judge is going to look at and say, well, what do you mean you reserve the right? You used all these other provisions. What other provisions are left? So that's the kind of stuff that really, what is the saying on Family Guy? Grinds my gears. That's it. It grinds my gears. So that's just the kind of stuff that makes people shake their head like, what the hell is going on here?
Yeah, it's supposed to provide you access to information, right?
Right. Not access to information. The whole premise of FOIA is to release the information, not hide it behind the curtain. So yeah, I'm having fun with that.
So, my experience, I'm slightly trailing you. I sent out, I don't know why I did this, by the way. I can't explain it, but I did. I sent out 2 FOIA requests to the SEC. They were asking basically for the same information. I don't know, maybe I changed a word, maybe, perhaps. But it was like many, many categories of documents. They responded, they summarized my many, many, many categories of documents to basically anything involving MMTLP or MMAT from 2021 to today. That was kind of like saying, you're asking for this. So I filed 2 separate requests. I got 2 separate responses, and they asserted different exemptions.
Yeah.
So
yeah, it's comical. It's really comical. This really is our government. I mean, this particular situation we're all in is really, we're watching our government run amok. It's really what we're doing.
Yeah.
So
the last thing I'm going to throw out, I'm going to let you think about it for a week. I'm going to throw out the topic because I think it's an interesting topic. Oh, one Cybertruck. I don't know if you saw it, but the first Cybertruck, if you know what that is, Tesla has a Cybertruck. The first one was produced off the line in Austin, and they'll be coming out sometime this year. There's like a huge number of orders. It'll be interesting how it plays out. Kind of has a very unusual look. So either people will like it or hate it, but they'll probably be interested in it. So to me, that's, as a Tesla fan, I'm looking forward to that. I think it'll be a big catalyst. Not legal or not financial advice. Last but not least, and I want you to think about this. You're
going to give me a whole week?
Yeah, I'm going to give you a whole week because it's a complicated issue. So, like companies are starting to make robots, right? You've seen that. And eventually they're going to be designed to take over all kinds of tasks, including, labor. So people now working in a factory, they may lose their jobs. And what they're going to do, I don't know. But maybe the robots will be much more efficient doing those kind of jobs. So maybe it'll increase productivity. But what happens to the people that get displaced? How do they kind of refit into society? And do robots, this is like the funny question, do robots deserve any rights or protections, especially to the extent that they get some level of AI that operates them and they have some, I don't know, I'm not going to call it consciousness, but something that they because maybe at some point in time, the idea will be they'll be able to learn by doing certain processes. And so that's, you know, we've never been faced with those kind of situations. I think that I will not be around maybe when these issues are at their height. But I think for like society, there are going to be like big questions about how to deal with people being displaced, how to maybe people might have more free time, issues about purpose, you know, in life.
So some bored 20-something 100 years from now can come back and watch this video and find out what we thought of ERISA's applicability to artificial intelligence in the workforce.
There you go.
Whether or not they have rights under the employer's health and welfare plan. Interesting. We can talk about that.
Yeah. And I like the way you said Borg 27. You said that? Because, you know, one of my names is Borghand.
Yes, Borghand.
Borghand, which is a tribute to old Star Trek and a tribute to my broken hand. Anyway, think about that, because I think that's an interesting topic. Well, I think it's an interesting topic. Maybe you don't. So if you come back and say that sucked, okay.
Can I do that? Do I have veto power?
You can, yeah, absolutely. Just so it's on the record, you have whatever you want to say, whatever topic you want to bring up. Hey, fair game, fair game.
Yeah, no, it's. I mean, I texted you today and said, "Hey, we want to talk about this because it became an issue." I talked to someone.
Right.
When I think about kind of this YouTube experience that we're having, again, first off, it's a lot of fun. It gives us a lot more freedom, and we can talk about these things. Because I said something to somebody the other day. At the end of the day, it's about keeping people smiling, keeping people engaged, keeping people motivated. And, if we can come on here and do that and talk about all these other things and educate people on them. And at the end of the day, Monday morning, tomorrow comes around, I go on a space, say, I watched your channel, you guys crack me up. That's enough for me. So that does it. So, and again, it's really all that it's about. So
the cash payments on the side are pretty good too, to be honest.
Richard, we're not getting cash payments on the side.
Yes, of course. I was kidding. Of course. If only we could be so lucky.
Jesus,
if only like somebody would. How come nobody? That's my concern. Really, I'm not concerned about the cash payments. I'm more concerned why nobody has offered me any cash payments. Why is that?
I'm going to tell you why. Richard, because we're not necessarily good at this.
Okay. That's a good reason.
And look, this is a shout out to Ramen Soups, man. I'm just messing. We're just having fun. You're entitled to your own opinion, but you got to make sure that, we can laugh about it too. So
so we're going to kind of end it here. To all of those who joined us today, thank you for joining us. If you see this at some other time, because that seems to be what happens, I hope you garner something from that. And, feel free to subscribe also if you so choose. We'd love to have you join us. So anyway, have a great day. Have a great rest of the week.
Yep.
We'll be back next week to talk to you about whatever comes up during the week. Take care.
All right. Talk to you soon, Richard. Yep.
Take care. Take care.